originally, the school told the parents she's experiencing mental health issues and some sexuality confusion and all that. And the parents wrote to the school and said, "Thank you so much for bringing this to our attention." And we're specifically saying we're getting her the professional help that she needs. We request that you do not have any private conversations with her in regard to this matter. Let us address this as a family and with the proper professionals. So they were getting help. They were addressing. It was a very positive, we are already doing this. And then the school continued to do this crazy secret gender transitioning stuff. So it was a really strong case. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
Thank you for joining us for another weekly episode of the Napa Legal Podcast. As always, if you enjoy the content we're putting out, we appreciate it if you like this podcast episode and subscribe to our channel on YouTube, Spotify, or wherever you are listening from. And with that, let's dive in. We have a lot to cover this week, including an impromptu decision to cover a case that we just got word of over the weekend. So we're going to start with the Supreme Court's decision in the First Choice case, which is a pro-life pregnancy center in New Jersey that we've covered earlier on in its life over the last year. Then we're going to go to two parental rights related decisions that were unfortunately not accepted for review by the Supreme Court. Then we're going to, we were not going to cover this originally, but the Fifth Circuit released a very important decision concerning the abortion pill being mailed across state lines. So we wanted to make sure we give attention to that because it's a big case. And then we will finish briefly on a hopeful note with a new tax credit program that includes pro-life resource centers in South Carolina. So with all of this to cover, we're going to jump in and talk about First Choice. So I'm going to give some factual background. I'm not going to get too deep into the weeds. It's a very technical case. This falls into that category that Joseph and I have been covering over the years of it's an important case, but maybe not exactly for the reasons that some of the mainstream news headlines are saying. Not that they're getting it wrong, but that the emphases are less about a substantive issue and more about technical legal procedures. So just a refresher, First Choice is a pro-life pregnancy resource center that serves women and families across the state of New Jersey. The now former Attorney General of New Jersey had a documented history of critically treating pro-life organizations in particular. And so this controversy started when the then AG issued a subpoena to the center demanding, among other things, its donors identifying personal information. So this covers both persecution of pro-life pregnancy centers as well as donor privacy, which is another issue that we cover quite often. So it's interesting because the factual background does show that the AG actually received no complaints about this pregnancy center, but nonetheless decided to investigate. He claimed that the investigation was centered on whether the pro-life pregnancy center misleads its donors into believing that it performs abortions. Won't comment on that, but there are a couple of common themes in prosecutions and investigations on pro-life pregnancy centers, and this is one of them. I don't know how many women are practically injured or even inconvenienced by going to a pro-life center thinking they're getting an abortion and being tricked into that. Doesn't seem to be much of a real issue. And like I said, there were no complaints from any women in New Jersey to the AG that launched this investigation. So the investigation was launched. There was a subpoena issued to First Choice asking for all this donor data. Before the subpoena's deadline had run, First Choice filed a federal lawsuit under Section 1983, which we've covered several times before, which is a way to redress constitutional violations. So First Choice files this federal lawsuit claiming that the subpoena chills its free speech and its freedom of association, especially because of the effect that such investigations can have on potential and current donors. And First Choice noted that several donors did, in fact, state that they would be less likely to give to the center if their information would be sent to the state's attorney general. So this is not a hypothetical. This is a real problem. So as this was going on, the federal lawsuit is filed first. The attorney general in New Jersey then files a lawsuit in New Jersey state court seeking to enforce his subpoena. First Choice's federal suit was then ultimately dismissed, which led to this Supreme Court case. The judge in the district court ruled that since the subpoena itself didn't impose penalties for noncompliance, right? It was basically justified as a request for information that would need a court order before it became a demand that was legally binding. And so the district court ruled that the center did not suffer an injury that was sufficient to grant standing in the case. So This went up on appeal, and the U.S. Supreme Court issued a unanimous ruling that First Choice's lawsuit in the federal court on 1983 should proceed. Justice Gorsuch wrote the opinion. He explained that the subpoena itself imposes an unconstitutional burden on the center's First Amendment rights, regardless of whether it's self-executing or whether a court order had been granted demanding that the information be turned over. The subpoena itself was a sufficient injury to justify standing. So this is important for the simple fact that when something like this happens, there is an ability to file 1983 suit and have it for organizations like First Choice to have their day in the federal courts. So there have been several important 1983 cases. We've covered a couple of them even this term. It's really important to show that even more subtle violations of First Amendment rights, right, the right to freedom of association in particular, including efforts to disband politically controversial groups or to chill the speech or privacy of donors, that denying these organizations 1983 actions doesn't survive judicial scrutiny. These are real injuries, real harms, and these cases can proceed. So this decision is important for many reasons. It helps with the 1983 precedent, but I just want to quickly highlight a practical point in this case. The outcome here is important because, like I'd said earlier, attacks by state attorneys general on pro-life pregnancy centers, it's not an isolated event. We've covered these investigations and prosecutions in several states, in the First Choice case in New Jersey, a couple of cases in New York, California, and elsewhere. They often come with a couple of different claims. One is requests for donor information, which is a problem. There are often spurious claims of consumer fraud, either because the abortion pill is being supposedly misadvertised or because there are claims that women are expecting to be able to get abortions from these places and they can't. And so these investigations and these lawsuits, they create quite a burden from the moment they're filed. And so it's just good to see that there is a ruling that gives a little bit more weight to these pro life centers to be able to have some legal remedies from the outset. So basically, the case in First Choice, the fight is over whether a state AG can control the legal process when they start to launch these investigations, right? If they, issue a subpoena that doesn't have penalties, but it's kind of a request for information, can they basically toe the line, claiming that the investigation isn't causing any practical injuries? And if they can do that, then they can just insist on, the pregnancy center has no cause to initiate a 1983 claim. They have to instead abide by the AG's timeline, the process in state court, respond when the AG actually files or requests a court order. And so it makes these organizations completely submissive to the will and the whim and the timeline of the state agency that's initiating these actions. But the reality is, first of all, these investigations are often targeted and political. We've highlighted before some of the questionable and problematic things that go on in abortion facilities, for example, and you don't see the same AGs going after them for consumer fraud or misleading patients or anything like that. So besides the targeted nature of some of these attacks, the reputational damage is real, right? These investigations, they're demanding donor info. It absolutely deters donors. We've seen proof of that in First Choice. It can make women in other cases, like in the Sisters of Life case in New York, the women who come to these places are much less likely to do so if they know that there are state agencies prodding around asking for sensitive information. There's real harm. So, providing a vehicle for these pregnancy centers to fight back on their own terms via 1983 claims and not wait until there's an injury sufficient enough for courts to be able to weigh in. I think it's an important tool to rein in these often ideological and always burdensome prosecutions. So, as much as I'd like to keep going, we have a lot to cover. And again, I think it's a very technical case. Lawyers and people interested, and especially those who are fighting to protect pro-life pregnancy centers, you definitely want to read First Choice and see the impact that it's going to have. But I think I'll stop there. So, Joseph, if you have any comments on this case, I'd love to hear them.
Yeah, Frank, thanks for running through this one. Definitely was excited to see it come out, and it is unanimous. So I just want to spend a brief moment on two different lines from Justice Gorsuch's opinion in this case. The first helps clarify what the actual constitutional issue was. And Gorsuch wrote, quoting a previous opinion, that the value of a sword of Damocles is that it hangs, not that it drops. very creative, also very illustrative of what's going on here. Basically, for anybody unfamiliar as I was before reading this case, the Sword of Damocles comes from an ancient Roman story. Basically, there was this Sicilian king Dionysius who had a very, very rich lifestyle, all the kind of foods and spoils that he wanted, but he was pretty unhappy because he was always afraid about somebody trying to take his life in his position. Eventually, someday, this guy named Damocles came and told the king, like, you must have such a blissful life. You have all these wonderful things. And the king was so annoyed, he said, hey, actually, do you want to enjoy my lifestyle for a day? Let you kind of see what it's like. And very excited, Damocles said, yes, of course, this sounds amazing. So Dionysius treated him like a king, gave him all the kind of rich food and lavish things upon him that he would want. Um, but he also hung a sword above Damocles' head and hung it with only a single strand of horse's hair. And Damocles was having a lot of fun until he looked up and saw this thing hanging above his head. And very shortly afterwards said, I don't want to actually be a king anymore. Can I please just go back home? And the analogy here is that First Choice suffered a constitutional harm because its donors were concerned about the negative consequences that could arise when their information was given to the AG's office, so much so that they didn't associate or give to the nonprofit. Basically, here, the sword that was hung above the head of First Choice and the donors was that their information would be doxed and given to the AG, and then who kind of knows where it goes from there. So the damage wasn't actually that the subpoena was executed and fell upon First Choice and kind of subjected them to the court-ordered harms, but rather just the fact that the sword was hung and that their donors then were no longer willing to engage in a constitutionally protected activity. So creative line, I love it. It was just kind of a fun little thing there, and I think it helps exemplify what the issue was aside from the technical 1983 stuff. And the second one that actually I think is going to hopefully have a little bit of an indicator about where some of the justices are in a decision coming up next year. A little bit of a longer paragraph. I'll read briefly from it, but the very ending is really where I want to key in on. Of course, it's wrote that the question before us isn't how badly the Attorney General has burdened First Choice's associational rights. The question is whether he has burdened those rights at all. By effectively restricting how First Choice may interact privately with its donors, the subpoena did just that. Were the rule otherwise, the government could channel the ability of disfavored groups to associate through narrow and state-preferred forms. In doing so, it could achieve exactly what the First Amendment forbids, marginalizing dissident voices and reshaping the marketplace of ideas to its pleasure, all while evading any legal challenge to its actions. And then this last sentence I think is really important. None of that is consistent with our Constitution, which prohibits subtle interference with protected liberties no less than it does heavy-handed frontal attacks. Now, I was reading this line immediately made me think of one of the biggest challenges in our religious liberty jurisprudence, and that's Smith analysis. So most of our listeners are probably familiar, but under Smith, a law that interferes with an individual's free exercise of religion, but is facially neutral and generally applicable, is likely to be upheld by the court. Essentially, under Smith, if the law doesn't explicitly target religion and treats everybody equally poorly, the odds are it will not be found unconstitutional despite the First Amendment's protections. For kind of a hypothetical example, think of a law that bans wine consumption for all people and has no exceptions. A Catholic priest will likely say, I need to use wine to practice, or I need to use wine in the Mass. That's a fundamental part of my religion. But under Smith, since the law doesn't say anything about religion and it applies to everyone, the priest would probably lose in court. Very fortunately, Smith has been cut back a lot in the last few years, and the Supreme Court, in a case we talked about last week, very recently agreed to hear another St. Mary's v. Roy that could also cut back against that Smith analysis. Basically, we talked about this briefly last week, so I'm not going to spend a whole lot of time on it. But the St. Mary's case will essentially decide if subtle departures from the neutral and generally applicable framework are sufficient to work around Smith. So if there isn't this explicit animus against religion, but it still targets religion in one way other than others, or if the general applicability is cut back in kind of more subtle and small ways, does Smith still apply, or is the religious plaintiff actually likely to win? So here in First Choice, the court unanimously agreed that subtle interference with protected liberties is inconsistent with the Constitution. And I doubt that St. Mary's will also be unanimous, but it's asking the exact same question. Are subtle departures from the First Amendment's protection of free exercise constitutional or not? First Choice, fortunately, they ruled no for the association claim. Hopefully in St. Mary's, they'll also rule no for the free exercise claim. Great. So with that, we'll move on to our second update, and we'll discuss how the U.S. Supreme Court recently, unfortunately, declined to hear a pair of parental rights cases. Now, we've talked about each of these cases in some form on this podcast, but this is a really important update. And to begin with, I'm going to call briefly back to Mirabelli v. Bonta, the Supreme Court's decision in early March of this year. In Mirabelli, California's parental exclusion policy was challenged by a group of teachers and parents. Basically, that policy, which is not only in this one California public school district, but lots of different school districts across the country have one at this point, requires staff to affirm any student's quote unquote gender transition by using the student's preferred pronouns and names. It's called a social transition, again, in scare quotes. Um, Basically, and if the child's parents disagree and say we don't want to treat our kid this way, we think that we think that our boy is a boy, not a girl, and shouldn't be using different names and vice versa. If the child's parents disagrees, staff are told to ignore the parents' wishes and continue affirming the child's new gender identity. The facts in Mirabelli and in other similar cases are pretty crazy. Basically, parents in a lot of these types of cases will tell school staff very clearly and explicitly that, their child's in therapy, we're handling this at home, they're struggling with mental health issues. Please just at school call my kid by the given name and let us handle this as we see fit. And then despite these very clear and very rationally based explanations, staff will just ignore these directions entirely, continue calling kids by the opposite pronouns, by the opposite name, and that sort of thing. And it goes pretty far. Staff will actually actively deceive the parents. So when they talk to the parents about their kid, they'll use the name that the parents gave the child. They'll use the correct pronouns for the kid, but then in school go and use the incorrect pronouns and the different name. So it gets pretty wild. Fortunately, in Mirabelli, the Supreme Court ruled that that policy violates both the free exercise and the due process clauses. However, that case came from the court's emergency docket or shadow docket, kind of depending on the term you like to use. And because of that fact, many pro-transgender advocates are arguing that it gave no conclusive precedent on the merits of the teachers' and parents' claims. It didn't issue a conclusive decision on whether or not these policies actually violate the Constitution. And that's because being on the emergency docket, Mirabelli wasn't argued before the court. They didn't follow their typical procedures for a very lengthy kind of process of reasoning through things very deliberately, given a very long, well-ordered opinion. It was an emergency decision that they heard quickly, issued quickly, and just felt the need to kind of move swiftly on. And really, while Mirabelli is heard on remand, California's attorneys are expected by some to argue that the court's decision doesn't actually bind the judge's hands, even though it's Mirabelli just in the lower courts. So it is a serious concern that because Mirabelli was on the emergency docket, it won't be taken seriously across courts. And then that brings us to these two other cases. One is called Foote v. Ludlow. The other is Littlejohn v. Leon County. Both have fact patterns pretty much the same to Mirabelli. And both were recently and surprisingly denied cert, even though they had garnered a lot of attention from the justices. Foote had been considered at private conference, I think 13 times. Littlejohn had been rescheduled to be heard at conference 9 different times. It was very much cases that the courts had spent some time looking at. They were briefed on the merits. They knew what the issues were. And they ultimately did deny cert in both. So both of these denials are certainly very disappointing, but Mirabelli still is a huge win. We talked a lot about Mirabelli in the past, so I'm not really going to spend too much time on that. I'd encourage anybody to listen to that episode from March. But basically, Mirabelli took some really important protections, applied it to a bigger context. So it is certainly a big win, and we're very hopeful that the court's reasoning in Mirabelli gets applied universally. Um, but I really just want to close with this. Beyond the disappointing missed opportunity to build upon Mirabelli's really important legal precedent, the most tragic part of these cases being denied is that they end with the parents losing. In Foote and in Littlejohn, both the parents lost at the circuit level. Now, personally, I love parental rights cases because I think the law in them is fascinating. I love kind of the questions that go on there. I think they present great opportunities to clean up some prior precedents. But I really care about these cases because of the people that are involved in them and the facts of each case. After being denied at the Supreme Court, the parents in these cases still don't know if their kids are being treated well or poorly by their public schools. Even though they're very emotionally unstable, they've given very clear instructions to the courts. The kids are often in therapy. I think in some, they've even attempted suicide. In some of these cases, the parents still have no idea how these public schools are treating their kids. It's terrifying to me that the government is claiming the power to override entirely fit parents, express instructions, and instead affirm a dangerous and harmful ideology in kids who need serious religious and therapeutic guidance. So I'm very hopeful that Mirabelli turns out to be the big win that we're hoping it was, and it likely is. But really, above all, I'm concerned for the parents in these situations and the kids in these situations. It's tragic that these didn't go up because the parents in these cases and the kids here are really left out to the state.
Yeah. No, it's probably not worth covering too much because, like you said, the Mirabelli is what stands. Foot and Little John are not going forward. I think it's unfortunate. I had talked to John Birch, I think, on our podcast about particularly the foot case. And it's unfortunate, I think, because it's such a good vehicle in that, often parents are challenging these things when they find out about something the first time, the teachers, the school is doing something behind their back. But the case is so strong here because in foot in particular, the girl was originally, the school told the parents she's experiencing mental health issues and some sexuality confusion and all that, and the parents wrote to the school and said, "Thank you so much for bringing this to our attention," and we're specifically saying, "We're getting her the professional help that she needs. We request that you do not have any private conversations with her in regard to this matter. Let us, address this as a family and with the proper professionals." So they were getting help, they were addressing it was a very positive, "We are already doing this." And then the school continued to do this crazy secret gender transitioning stuff. So it was a really strong case. And I know John Birch was hoping he was litigating this with ADF. They were really hoping this would be a good vehicle to bring this forward. But yeah, like you said, as it stands, Mirabelli gives us some good precedent on this case. And the most hopeful conclusion, like you hinted at here, is that um courts that the Supreme Court denied these with the hope that courts are going to follow Mirabelli. So it'll be interesting to see when the next district or circuit court ignores Mirabelli, and it goes back up to the Supreme Court, if the Supreme Court is actually going to take one of these next term or is going to say, cert granted, vacated, reconsider in light of Mirabelli. So I think how much weight this emergency docket case in Mirabelli has kind of remains to be seen as lower courts are forced to apply it. All right. And with that, we will turn to our impromptu discussion. I'm not going to go into too much depth because I just read through this case this morning. It was sent to me over the weekend, but we want to cover Louisiana versus FDA out of the Fifth Circuit. So this is we've covered this issue before, but now we have a really big decision. So the gist of this case, it's a long-standing battle now over the FDA's decision in 2023 under the Biden administration to allow mifepristone, which is the abortion drug, to be prescribed without an in-person doctor visit, and therefore allowing it to be mailed to women, including across state lines. So this is problematic for more than one reason. First of all, mifepristone is a dangerous and understudied drug that not only kills the unborn baby, of course, that's its intent, but also has dangerous side effects for women. This is admitted by the FDA studies. Like there are complications, there are emergency situations that happen when women take this stuff. And so allowing it to be prescribed without an actual in person doctor visit or any kind of oversight is deeply troubling. And then also legally, this regulation completely undermines the ability of states like Louisiana that have banned abortion to enforce their own laws within their borders. So the background here, Louisiana filed a lawsuit asking for the regulation to be stayed. This is the regulation that dispensed with the in-person doctor visit. So um, the history is interesting. So mifepristone was approved by the FDA in 2000. Much stricter requirements back then. 3 in-person doctor's visits before it would be prescribed. Plus, the doctors had to monitor and report on any serious complications that happened as a result of women taking it in 2016. It doesn't seem that there was any indication that it was particularly safe, but nevertheless, the 2016, the FDA lowered the requirement from 3 in-person doctor visits to 1 in-person doctor visit, and the reporting requirements for complications were mostly dropped. I think deaths from the medication had to be reported, but otherwise, a lot of the adverse reactions no longer had to be reported. It's unclear why, if this thing is dangerous, they're lowering restrictions and reporting requirements. But the trend continued, and in 2023, the in person requirement was dropped entirely, despite the fact that this is pretty obviously an unsafe way to deal with such a dangerous medication to just let women have like a telehealth Zoom visit and then mail it to them across state lines. Um, that's the generation of the lawsuit. The district court heard the case, Louisiana versus FDA. They seemed to agree with Louisiana's reasoning that there were problems with the way this regulation was done, that it actually is infringing on Louisiana's rights. But they ultimately refused to grant a stay, at least partially because the FDA claimed that it was still doing further research and considering changing the rule on this issue. Now we're in 2026. The FDA still has not changed its rule on this issue. And so the Fifth Circuit reversed course and did grant the stay. It's an interesting opinion. I'm just going to give a couple of highlights. You can read it for yourself if you're interested in pro life work. This could be a watershed case, but it's also a very short opinion. It's about 18 pages in the PDF. So the Fifth Circuit here focused on the district court's analysis for a stay. A lot of this is technical about what are the requirements before a court should issue a stay. They did ultimately rule that the lower court got it wrong and issued the stay. One of the key findings was that the lower court actually abused its discretion by not addressing whether removing the in person visit requirement was an arbitrary and capricious decision. So I want to I'm going to skip over most of it because a lot of it, again, is the technical, like four-part consideration for when you do or don't grant a stay. Going to skip a lot of that. There's also some interesting standing doctrine here that I want to highlight. So, the Fifth Circuit here, turning to the standing issue, this is what I want to cover. They argue that Louisiana does, in fact, suffer a legal injury as a result of the FDA rule. And this is the important part of the ruling, at least in my mind. In particular, there are two injuries. There's an injury to Louisiana's sovereignty, and also financially, there's an injury to the state. So on the sovereignty issue, I think this is the crux of it, and this is the substantive, like meaty issue that needs to be addressed, right? If doctors can mail abortion pills into a state that bans abortion without an in-person visit, this makes it practically impossible for the state to actually create and enforce its own legal code, right? It's not hard to follow that argument. Mifepristone is illegal in Louisiana. The FDA's rule, the purpose of the rule is to expand access to mifepristone and has had this effect. It has expanded access. It's now easy for people to receive mifepristone in the state of Louisiana where the drug is illegal. So it's pretty obvious that Louisiana is being injured. They can't enforce their own laws, right? And the disturbing factual record here makes this clear. The case notes that about 1,000 illegal prescriptions of mifepristone occur in Louisiana every month due to this rule. So the FDA rule causes a direct injury to Louisiana. It's pretty much impossible to enforce its own abortion laws when the federal rule allows these abortion drugs to be mailed into the state. I also it's interesting. This is a really good narrative thing to point out. That Judge Duncan's excellent opinion here also addresses the financial injury to the state of Louisiana, which maybe is not first in people's mind when they're thinking about this. But Louisiana has identified on the record in this case concrete cases where it has had to pay Medicaid funds to women who are on Medicaid in the state of Louisiana who needed emergency care caused directly by injuries that they incurred by ingesting mifepristone that was mailed to them from out of state. So there's a direct link between this rule and the mailing of mifepristone and financial injury. Louisiana has to pay out money to women who are dealing with the medical fallout of this dangerous drug. And it's not a surprise. FDA's own label confirms that I think the number is anywhere from 2.9 to 4.6% of women who take mifepristone will require emergency care when mifepristone is prescribed with an in-person doctor supervising access to the drug. When there's no doctor, we can assume that the number would probably be higher. But regardless, there are women who are being injured enough where they need emergency care from taking this stuff. Therefore, the mailing of an abortion drug into Louisiana, in addition to causing illegal abortions, right, and the injury of killing unborn babies in Louisiana, where that's illegal, is also costing Louisiana money for emergencies that its laws are meant to prevent because you're not supposed to be able to get mifepristone in Louisiana at all. So, again, read the analysis on why the district court got the stay question wrong. These injury standing questions are quite interesting and important, I think. And so the Fifth Circuit, for all of these reasons, has granted the stay against the FDA rule, allowing mifepristone to be mailed without the in-person doctor visit. I think it's a big legal win against, remember, the number one cause of abortion in America is chemical. I think it's about two-thirds of abortions happen through drugs. And so states like Louisiana that have, heroically and for the common good banned abortion need to be able to keep abortion drugs from being mailed into their states. It's a big win. We'll keep watching it. This decision has already been appealed to the U.S. Supreme Court, which makes me believe, because I think this opinion just came out on Friday, that the uh, the FDA knew what Fifth Circuit panel it had drawn and that it was probably going to lose this case. So the Supreme Court has a cert petition and we'll be watching this one closely. And obviously, if there's a grant and the U.S. Supreme Court takes this up, then this will be a big case to watch.
Yeah, Frank, thanks for adding in this case this week. I was really glad to see another great opinion come out of the Fifth Circuit. They had that recent Ten Commandments case as well, where they held that requiring the passive display of the Ten Commandments in public schools is an unestablished clause violation. So another great opinion here. I just want to spend a moment addressing the initial removal of the in-person requirements to get the abortion pill. Now, abortion is a terrible thing. It's directly taking innocent, really the most innocent human life. But I would have to imagine that even if there's somebody who's in favor of abortion, removing those in-person requirement visits is just a terrible idea. Just to help illustrate this, I'm a type 1 diabetic and need to take insulin. I have for as long as I can remember and probably will my entire life. I'm unable to get a prescription for insulin without keeping a somewhat regular schedule of doctor's appointments. There's more regulation for me to get insulin, which is a very simple drug, than for someone to get an abortion pill, which has serious medical consequences aside from the fact that it kills an unborn child. There's a litany of documented cases where there's serious bleeding, emergency care. Like you said, the FDA's own label admits that a somewhat significant percentage of women who take this, even with the in-person requirements, will require emergency care. Not even to mention the mental or other physical trauma caused by taking it. Removing very basic medical requirements for a drug as dangerous as this really makes no sense, I think, regardless of your position on abortion.
Yeah, and obviously, we're grateful to Judge Duncan, who is has been a friend of the Napa Legal Institute. Is really just an amazing judge. He gave our keynote at our inaugural Good Counselor Project Lawyers Conference in 2025, and we're just really impressed with the work that he's doing on the Fifth Circuit. So, with that, we will finish on a little note of hope here. Quick note of NA. We're not going to go in depth because there's not too much to say, but um, it's always important to highlight these little policy wins. So South Carolina has now made a tax credit available for donations to pregnancy resource centers. This recently came through both the South Carolina House and the Senate. It was a unanimous vote to pass this Pregnancy Care Tax Credit Act. And the act basically just makes an income tax credit for any donations given to a pregnancy care center, maternity home, residential program for victims of human trafficking. So important pro-life work to help women and unborn children. Currently, 30 such centers and homes that qualify exist in the state of South Carolina. They receive roughly $14.7 million in charitable contributions each year. And with the tax credit, it is likely that those numbers go up. There are similar laws in other states like Kansas and Missouri. But there's an important use of policy, right? We use policy to make sure that we are funding and supporting good things and not funding or supporting bad things, put simply. And so this is a great thing. This gives people the ability to make, not just tax deductible, but actually get dollar for dollar income tax credits for donations to these organizations that are doing really important work. Like I said, everything from helping vulnerable women with difficult pregnancies to helping aid victims who have survived human trafficking. So a great law and a great example of how you can use tax policy to promote good things in your state.
Yeah, I've done a little bit of research on other states that have similar laws on the books, and there's kind of a different couple different sets of tiers of like how much total money can be credited across the state, the type of tax credit it is. At least as far as I understand it, South Carolina is in like the top tier, so it's among the most total credits that can be given. It's like the strongest type of credit. Um, Not being a tax professional, some of the terminology might be a little bit inaccurate, but more or less, it's amongst the strongest of these types of laws. So it was great to see this pass unanimous and great to see this move in South Carolina.
All right. And with that, we thank you for joining us for another episode of the Napa Legal Podcast. So, as we said at the beginning, we appreciate if you like and subscribe wherever you're listening. It really helps us to continue to do this work. And if you want to support us, you can do so and also find out what we're up to at Napa Legal at www.napalegalinstitute.org. So we hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious liberty and the work of faith based nonprofit organizations. So we'll talk to you next week. Thank you for joining us, and God bless you all.